Well, welcome everyone to another episode of Level Up Law, where every Tuesday at noon, South Carolina Legal Services is leveling up your legal knowledge about an area of law that we practice in. I'm attorney Susan Ingalls here with our producer, Sally Ingalls, who is our communications manager here at South Carolina Legal Services. And you are looking live at attorney Holly Webster, who is an Equal Justice Works Housing Justice Fellow in our Greenville office. Today, Holly will be reviewing common notices relating to an eviction in South Carolina. In other words, what do eviction papers mean and how much time do I have to do something about them? But before we get started with Holly's presentation, we do want you to know that, as always, this is not legal advice. It's just general information for the public. If you need the help of a lawyer, call our intake line here at South Carolina Legal Services, or apply online. The information on how to do that will be provided at the end of today's presentation. Now, also, you see a QR code on your screen. We want you to scan that QR code if you'd like to sign up for our newsletter. We'll provide that same QR code at the end of the presentation as well. We'll just give you a few seconds here to try to scan that, but just keep in mind that you'll see that again at the end of the presentation if we didn't give you enough time to scan that one. Now, our next QR code we want to show to our listeners is the QR code that you can scan to send us an idea for a Level Up Law episode. We're always looking for topics, and I'm glad to say that we're already getting suggestions from folks who have scanned the QR code. Don't know what that sound is, but we'll move on. But if you want to give us a topic that you really want us to cover, please do scan the QR code and do that now. Also, we'll be reaching out to those of you who have already filled out the form for a Level Up Law episode suggestion. We do thank everyone who has submitted those. Also, we'd like to remind the viewers that this episode that Holly is giving us today will be posted on the Level Up Law playlist on our YouTube channel at SC Legal Services. You can go there anytime to see this and the over 100 episodes that are already there on other topics. Now, if you're watching the replay of this episode, while you're here on our YouTube channel, please hit that subscribe button and the notification bell. We want to be sure you always know when we post a video here on our channel. And also be sure to look out for our social media posts, Twitter, Instagram, LinkedIn, and Facebook, and now TikTok. That way you can get all the up-to-date information that we provide, not only here on Level Up Law, but all the other resources that we're putting out there as well. All of that information is going to be on that last slide that Holly will have for us in her presentation. Now, Holly has agreed to answer questions if there's time allows, and there are some points during her presentation in which you can ask questions about what she is talking about at that moment. So please do put questions in the question box on your screen when you have them about a particular item that she's talking about. Well, that's all from me. Let's turn it over to Holly Webster for common notices relating to an eviction in South Carolina. Take it away, Holly.
Thank you, Susie, and good afternoon, everyone. So I will be discussing common notices related to an eviction. And important notes I would like to make before I really get into the presentation is that public housing and subsidized housing are covered by mountains of federal law. There's more and different rights and responsibilities that apply when it comes to notices to tenants that live in those types of housing. So for this presentation, I will be focusing on common notices related to private landlord tenant evictions, and then possibly discussing common notices related to public housing and federally subsidized housing in 2023 in another Level Up Law episode. I would also like to note that with this presentation, I will not be including pictures of notices from the landlord, as those do vary. Although they can still be proper and look different, I will not be including images of those, but I will be including images of notices from the court, from the SC Court's website for you to view during this presentation. Now, it's important to note that with evictions, there's a two-step process. The first step being to terminate, the landlord needs to terminate the lease agreement, and that will be, that's where you will see the notices from the landlord, as well as the second step being that the landlord needs to file an action in magistrate court, and that's where you will see the notices from the court come into play. So the first section will be on notices from the landlord. The first notice will be a 5-day written notice of non-payment. This notice can be found in the lease agreement or in a separate writing. So starting with the 5-day written notice of non-payment in the lease agreement, this is covered in section 27-40-710B of the Residential Landlord and Tenant Act. If the landlord provides the 5-day written notice in the lease agreement, the statute does include language that would be considered proper language for a 5-day written notice of non-payment in a lease agreement that I've copied and pasted onto the slide for you to view. It says, if you do not pay your rent on time, all caps, this is your notice. If you do not pay your rent within 5 days of the due date, the landlord can start to have you evicted. You will get no other notice as long as you live in this rental unit. Like I said before, if the landlord includes this language verbatim in the lease agreement, this satisfies the notice requirement for a 5-day written notice of non-payment in the lease agreement. Please keep in mind, though, that if the language in the lease agreement is not exactly how you see it on the screen now, and it's not word for word what I've copied and pasted on the slide, it can still be considered proper notice. The statute requires that it at least be substantially equivalent to this language, if not verbatim what you see on the screen. And if the landlord includes this language in the lease agreement, the landlord is not required to give a separate written notice to the tenant in order to satisfy the notice requirement in the statute. It's also important to note that the language in the lease agreement needs to be conspicuous. It needs to be clear. It needs to stand out. It cannot blend in with the rest of the language in the lease agreement. Examples, as you can see with the statutory language I've copied and pasted on the slide, if you do not pay your rent on time is in all caps. Another example would be if it was in bold, underlined, all caps, all three, or just one. Any way that it could be arguably conspicuous and stand out to you in the lease agreement would be considered, that would be a requirement. And if it meets all the requirements on the slide, then it would be considered proper notice. Does anyone have, if there are any questions, Sally, I don't know, about this notice before I move on to the applications to test their knowledge of this?
We don't currently have any questions about this notice, but if you have a question about the 5-day notice, we'll give you a couple seconds to type it in the chat. We did have one question. So you mentioned that you won't be covering public or subsidized evictions because those maybe follow a different process.
So there are more rules and that are apply in addition to the rules that I will be mentioning in this presentation. But the hope is that I will be covering those notices for those types of housing in a later episode, just focusing on public housing and federally subsidized housing notices, just not in this presentation.
Okay, great. Thank you. We did have a question about that, over whether we would be covering that information. So if that was your question or you had a similar question, stay tuned because we will have that in a later Level Up Law episode. We have gotten another question about the 5-day notice. Does an email count as a written notice?
Okay, so I will actually address, well, so yes, I wanna focus on the separate writing, because I do have a slide on that, but does anyone have any questions about the 5-day written notice in the lease agreement?
It doesn't look like we've had any other questions come through, and if we do, we'll save them for the overall question part at the end of the presentation.
Okay, all right. Well, I will hit that question when I reach the 5-day notice to pay rent in a separate writing. Okay, I will move on to the applications. So the first application, just to test your knowledge of the 5-day written notice in the lease agreement, it says that the tenant's lease agreement states that if the tenant does not pay rent by the 5th of the month, they will have to pay a late fee. Now, note in this application, the landlord did not provide the tenant with a separate written notice of non-payment. Is this proper notice? So the answer is no. This is not proper written notice because it only notifies the tenant that they will need to pay a late fee if they fall behind in their rent. It does not include the statutory language, and it does not include language that's substantially equivalent to the statutory language. Therefore, this alone is not considered proper notice. Moving on to application 2, the tenant's lease agreement states that if the tenant does not pay rent by the 5th of the month, they will need to schedule a meeting with the landlord. Note, the landlord did not provide the tenant with a separate written notice of non-payment. Is this proper notice? Once again, this is not proper notice because it does not contain statutory language or language substantially equivalent to the statutory language. It's just notifying the tenant that they need to schedule a meeting with the landlord. And so that alone is not considered proper notice. So now we are moving on to the 5-day written notice of non-payment in a separate writing. This is also covered under section 27-40-710B of the Residential Landlord and Tenant Act. The statute requires that this notice be in writing, that it notifies the tenant that they are behind in their rent, that it states that it gives at least 5 days from the date in the notice for the tenant to pay the past due rent, and the landlord's intent to terminate the lease agreement if rent is not paid within that period. Now, to address the question about the notice, the 5-day notice being in an email, of course, I don't know specifics as far as what's contained in it. The statute just has the following requirements. With technology and everything advancing, I don't particularly see why it would be considered improper solely for it being in an email, but as long as it has the statutory requirements, it could be argued that it's proper notice, as long as it meets the requirements that you see on the screen. Are there any additional questions that may have come up about a separate written notice? Separate writing for a 5-day written notice of non-payment?
We haven't had any come in yet, but once again, we'll pause for a few seconds. If you do have questions about this portion of the presentation, go ahead and type them in the question chat and we will get them answered while we're on this topic.
That was a very good question, by the way, for whoever put that in there. While we're waiting, I do want to say, just to kind of piggyback on what I mentioned earlier about with technology advancing, the Residential Landlord and Tenant Act has been here for a long time. So of course, there are a lot of situations that don't pop up as far as like emails and text messages, and is this considered proper notice? And there's been debate, I know, about text messages, and maybe the same debates on emails being considered proper. And I've, it really, with that, it's probably going to be on a case-by-case basis. It really does depend on the judge. But this is what the statute requires when it comes to a separate written notice for 5-day written notice of non-payment.
We did have a question come in. So one of our attendees said as a clarification, so if rent is due on the 20th, that you then have 5 days to pay within, like 5 days from the 20th to pay without getting any fees.
So it's kind of getting a little bit more specific. It really, this is just talking about the type of notice that the landlord gives. So it's starting to sound a little bit more specific. With that situation, it's just important to look at your lease agreement first and see if any notice in the lease agreement addresses non-payment. And then also, if not, to expect some type of written notice from the landlord regarding paying your rent. But as I'll say later on in the presentation, just keep in mind that your situation may be a little bit, your situation could be different depending on what your lease agreement says. A lease agreement could give you a lot more time than what's required by the statute. So it's just important to thoroughly read your lease agreement to understand what your options are, because you may get more than 5 days depending on what's in your lease agreement. What the landlord cannot do is subtract from the 5 days and say you only get 1 day or 2 days, or if you're immediately behind, I'm filing an action. I mean, that's not considered proper. So it just really depends on what your lease says. Read that thoroughly and understand that your situation may be a little bit different depending on what's in your lease agreement, as long as it does not directly conflict with the statute.
Okay, great. Thank you for that clarification. And this might be something that, this might be a question that we can come back to at the end, but I'll go ahead and ask it while it's been asked. But what would be the, like the proper avenue if your lease has mistakes in it?
You mean if it
so maybe
doesn't?
If there's
oh, sorry,
you
maybe
went if there's inconsistent information. Oh, sorry. Maybe if there's like inconsistent information in the lease, or you thought it said one thing, or they told you it said one thing and then it says something different. And that might be a question that we can come back to at the end, since that's a more general lease question.
Yeah, I think I have a slide that will kind of cover that too. And if not, we can definitely hit that question again later on.
Okay, great. Thank you. Well, then I think we are ready to move on to the next document.
All right, so I do want to get into applications for this, the 5-day written notice of non-payment in a separate writing. So application 1, a landlord walks up to a tenant who is behind in their rent and tells the tenant to pay within 5 days or vacate the rental unit. Note, the landlord does not include proper written notice according to the statute in the lease agreement. Is this proper? And the answer is no. And the reason is because the statute requires the notice to be in writing. Simply telling a tenant that they have to vacate within 5 days or pay their rent, that's not proper. It has to be in writing. The next application states that a landlord puts a paper on the front door of the tenant's rental unit that reads, "Your rent is late, get out." The lease does not include proper written notice according to the statute. Is this separate writing proper? Well, it's in writing, but it's still not proper because it does not give the tenant 5 days from the date on the notice to pay the past due balance. It simply just tells them to get out because they're behind. So moving on to the next notice. So now we're moving on to notice of non-renewal, I'll hit the 7-day notice, 30-day notice, and a 20-day notice. The first one will be a notice of non-renewal for a week-to-week tenancy. So a tenant who makes weekly payments to the landlord in order to stay in the rental unit. And this is covered under section 2740-770A of the Residential Landlord and Tenant Act. And the statute requires for this notice to be considered proper. It needs to be in writing. It needs to specify a termination date and give the tenant at least 7 days before that termination date to vacate their rental unit. So I will pause and see if anyone has any questions about this type of notice of non-renewal.
So far, we haven't gotten any specific ones about this. We have gotten some more general questions that we'll save until the end of the presentation. I'll give people a few more seconds to submit a question before we move on. All right, I think we're ready to move on to the next one.
Okay, so let's move on to some applications. Application 1, a landlord gives a tenant a written notice that states they will need to vacate the rental unit by a deadline that is 15 days after the date on the notice. Please note the tenant is living in private housing on a week-to-week tenancy. Is this proper notice? And the answer is yes. The statute requires that the landlord give the tenant at least 7 days. And so giving the tenant more than that does not make the notice improper. So in this case, that is why this would be considered proper notice, 7 versus 15. And then application 2, a landlord meets with the tenant in the landlord's office on December 12, 2022, and tells them they need to vacate on December 19, 2022, which is exactly 7 days after the date of their meeting. Note, the tenant is living in private housing on a week-to-week tenancy. Is this proper notice? No, because as I stated in a previous application, the statute requires that the notice be given in writing. So now I will move on to a notice of non-renewal for a month-to-month tenancy, which is where the tenant makes monthly payments to the landlord in order to stay in the rental unit. This is covered under section 27-40-770B of the Residential Landlord and Tenant Act. And the statute requires for this notice that it be in writing, that it specify a termination date, and give the tenant at least 30 days before that termination date to vacate the rental unit. And anybody has any questions about this one?
Once again, we've gotten some other questions that I think will be good for us to circle back to as a general question at the end of the presentation. We did get one question that seems specific to this. Is there, I guess, a special consideration, or is it the same process if it is a month-to-month lease that comes with a year-long lease?
I don't know if I understand. So it's like they had a year-long lease and it terminated, and now they're month-to-month. Is that what it is?
That clarification isn't in the question. With my personal experience with leases, I would think that maybe that is the situation. Maybe it was a year-long lease that after a year went month to month. And so at that stage, would it then fall under the month-to-month information because of the switch?
Yeah, so if someone has a year-long lease and it expires, but they continue to make monthly payments after the fact and they're in private housing, it moves on to being a month-to-month tenancy. The terms of their lease agreements would still apply, but they would be considered a month-to-month tenant if they do not have a current lease agreement.
Okay. Okay, we did get another question about month to month. So the landlord would only be able to file for eviction if the tenant is still there after the 30 days when the lease would be terminated.
So, yeah, so the landlord would have to give the 30-day written notice before they can file an eviction action. And actually, this kind of goes into one of the applications that I have to kind of just elaborate that they can't give a 30-day notice and then file an action before the 30 days are up. The 30 days have to go by before they can file an eviction action against the tenant, the month-to-month tenant. Does that answer?
Okay, great, thank you. Yes, that seems to have answered the question.
All right. Any other questions about month-to-month notice of non-renewal for month-to-month tenancy?
Does the retaliation prohibition still apply in this scenario?
So I honestly do not know. I'm not certain about that. I'm sorry.
Okay.
Wait, but I don't know like what specifically. I mean, I'm not sure what they're in what scenario. Like when, I guess I'm confused.
So like do the protections, I guess of like against landlord retaliation still apply with the month-to-month lease?
I don't really, I don't know what outcome would happen if what the outcome would be if someone tried to accuse a landlord of retaliating against them for giving them a notice of non-renewal for a month-to-month tenancy, just because the landlord doesn't have to give a reason when it comes to this type of non-renewal. It doesn't have to be they terminate the lease. You can be current and everything and still get this type of notice if you're month-to-month. The statute, all it requires is that they give you this. I don't know how successful you would be on that. So hopefully that answers the question.
Yeah, thanks. And if you ask that question and you feel like you need a little bit more clarification on that, feel free to send in another question and we can circle back at the end of the presentation.
Yes.
Otherwise, I do think we are ready to continue on.
Okay. So let's get into our applications. On December 15th, 2022, a landlord posts on the front door of tenant's rental unit a notice that states the lease will terminate on December 31st. Tenant is living in private housing on a month-to-month tenancy. Is this proper? Remember, you're on a month-to-month tenancy, you're entitled to a 30-day written notice. That's why this is not proper, because it does not because the statute requires that the landlord give the tenant at least 30 days. In this case, the landlord did not give the tenant 30 days, which is why it's not considered proper notice. Application 2 states that on December 15th, a landlord posts on the front door of a tenant's rental unit a notice that states the lease will terminate on February 15th, 2023. Note the tenant is living in private housing on a month-to-month tenancy. Is this proper? Yes, so this is actually like our the previous application with a week-to-week tenancy. Statute requires that the landlord give at least 30 days, but if the landlord decides to give 60 days or more, the landlord's allowed to do that. It does not make the notice improper, which is why under this application, this would be considered proper. But applying the same facts as application 2, what if the landlord finds out the tenant is still in the unit on January 2nd and files an eviction action on January 3rd? Is this proper? No, because the action was filed before the before the deadline that was given to the tenant. Also, even if the landlord gave the tenant the 30 days required by the statute, the landlord filed the action before the 30 days even passed. So this would not be considered proper. And I think this is what I addressed earlier as well when someone asked a question about that. but I'm going to move on to 20-day notice to vacate. So now I'm going to talk about, so just briefly, I'm going to try and hit the tenancy at will. This is not covered by the Residential Landlord and Tenant Act, but it is covered by other landlord-tenant statutes. So Section 2733.10.3 defines the tenant at will as every other person other than the owner of real estate, except for a domestic servant and farm laborer, using or occupying real estate without an agreement, either oral or in writing, shall be deemed a tenant at will. And then 2730-35-30 excludes the tenant at will from being deemed a month-to-month tenant. And 27-35-130 states that all tenants at will shall vacate the premises occupied upon 20 days written notice. So the signs that you may be a tenant at will are that there's no agreement between the landlord and the tenant, oral or written, no rental payments, and the property was obtained with permission from the owner. So the person is not a trespasser. One example from case law would be Bruce v. Durney, which is a 2000s case, where the Court of Appeals held that children were really the daughter and her husband, the son-in-law, living on her father's property without paying rent and without a rental agreement could be considered tenants at will. Ultimately, the court determines the classification of the person and whether they are considered to be a tenant at will. So it's really up to the court, but it is important to note that if you are considered to be a tenant at will, you're entitled to that 20-day written notice. Section 2735-130 of the SC Code of Laws requires that that notice be in writing and gives the tenant at least 20 days to vacate the dwelling unit. So if there are any questions about this type of notice, I will pause and wait.
So we did get one question about, I guess, the process of vacating. So if your landlord didn't do things the right way, like didn't follow the proper procedure and with these notices, and you vacated, even though they didn't follow the correct procedure, how long after that do you have in order to like challenge the landlord or go after them for breaking that process and those laws?
So that sounds like it kind of exceeds the scope of this presentation, especially if you've already vacated the property. So, I mean, I'm trying to figure out how to can you repeat the question? Sorry, because I'm not sure. I think it sounds kind of like outside the scope of this presentation. But go ahead. Sorry.
Yeah, so I guess essentially, if after watching this presentation, you've realized that your landlord didn't do things the right way, but you vacated anyways, is there an avenue for going after the landlord for breaking those laws even after you've vacated?
So honestly, I'm not really sure, because the purpose of an eviction action is to obtain possession of the unit, but you've already given them possession of the unit. So I don't necessarily know. I mean, there's more information that I would need, but of course I can't get too far into that because then I'm getting away from the general information. It really depends on your situation. It depends on what it is you're trying to seek if you've already given up the unit. So I mean, outside of that, I can't really get too deep into that, because I would need more information than that.
Yeah, and this is Susan. I would also say regarding that question that I think they're talking about what would the statute of limitations be to sue the landlord under the lease. And I think, Polly, you're right. That's really a question that also involves what you would be trying to hold the landlord responsible for, and whether or not it's something that should have or could have been dealt with in the eviction action. So that's probably a little too specific and beyond the scope of what you're able to really do, since we did say that this is just general information and we can't really answer questions about specific cases. Even that's not a specific case, but every case is different when you're talking about suing your landlord back. So that would be probably another episode we'll get you to do. This is all great information, but I just wanted to mention that for that viewer, because it is a good question.
Yeah, it is a good question.
As lawyers, we find ourselves way too often having to say, it depends.
Yeah, there's so much information that would need to be shared for me to even go into that.
Back to you.
All right. So
Well, thank
now
you. I will say that. Oh, sorry. I was just going to say that viewer did also send in a message to say thank you for trying to answer the question, even though there may be additional circumstances.
Thanks. All right.
Yeah,
so I
think if and we'll say this at the end too, but if you do think that as any of our audience members think they have a situation where they do need a lawyer, definitely watch till the end of the presentation so you can see all the information about applying for our assistance with something like that.
Yeah, absolutely. So I'm going to move on to the 14-day notice to terminate or cure lease violations. So this type of notice, the 14-day notice, is covered under Section 274710A of the Residential Landlord and Tenant Act. And the statute requires for this type of notice that it be in writing, that it specify the acts and omissions that constitute the breach, what did the landlord accuse you of doing or not doing, and then states the rental agreement will terminate in no less than 14 days after the date in the notice if the breach is not remedied within the 14-day period. So I will pause and see if anyone has any questions about this type of notice or already posted any questions about this type of notice.
We don't have any yet, but again, we'll give people a couple of seconds to submit a question before we move on. Okay, I think we are ready to move on to.
All right, so let's move on to some applications. So the first application, just to test your knowledge of this type of notice, landlord gives a tenant a notice that tells them they have 14 days to cure a breach and that the tenant knows very well what they mean by breach. Is this proper? No. This is not proper because the landlord did not specify the breach like the statute requires. They did not specify it in the written notice. It's not enough for the landlord to just assume that the tenant knows, or maybe they just truly believe you know because we talked about it type situation. That's not sufficient. They have to specify what the breach is in the lease, in the 14-day notice. And application 2, a landlord gives the tenant a notice that says that an unauthorized guest is living in the rental unit and then tells the tenant that the lease will terminate in 14 days. Is this proper? And the answer is no. This is not proper because the tenant is entitled to an opportunity to cure the breach by removing the unauthorized guest within the 14 days given before the landlord can terminate the lease agreement. Simply telling the tenant that they have to leave in 14 days completely violates that right that they have to fix what the problem is in this particular situation. So important notes. I think I mentioned this earlier about the notices I mentioned in here are required under state law. Your lease agreement may require additional notices. It may expand on the notices that are required by state law. So it's important to thoroughly read your lease agreement. An example would be if the lease gives you a 30-day notice to cure instead of a 14-day notice to cure. It doesn't mean that that's improper, but it's important for you to know if that's an option for you in your lease agreement. And then the lease cannot, but the lease, like I said earlier, I know I said this, the lease cannot reduce the notice period or substitute verbal for written notices. So it can't say, well, instead of a 14-day notice to cure, you're going to get a 5-day notice to cure. That's not proper because it directly conflicts with the statute. On top of that, when it comes to written notices, the lease can't say you're going to get a verbal warning and that satisfies the statute. No, it doesn't. It conflicts directly with the statute. And Sally, were there any general questions about the notices from the landlord before I go into the notices from the court?
We do have some general questions. I'm actually going to let Susie ask because she'll know more specifically what questions are good to ask right now. So I will turn it over to Susie.
Oh, before you start, I do have another slide that may answer at least one of the questions I think someone was going to try to ask earlier. So what happens if the landlord files an action without giving proper notice? The tenant would have an improper notice defense. The tenant should request an eviction hearing with the court, which I'll get more into in the notice from the rule to vacate when I hit that slide. But at the hearing, the tenant should explain that he or she did not receive proper notice to terminate the lease, ask the court to dismiss the eviction. It's also good to know why the notice is not proper and be able to explain that to the judge, why you believe you did not receive proper notice. Okay, so if there are any questions, general questions about the notice from the landlord before I move on to the notices from the
Yeah, Holly, I'm just kind of reviewing the questions here. Let me know if this is one you've already answered with the presentation, but there's one question that says, if you have been away from home and don't know when the written notice was given because no date is on the written document, how do you proceed?
Okay, so that's okay. So, I mean, it's tough on what would happen if you made the argument in court that a notice that's improper, because you're supposed to be given a certain amount of time depending on what the notice is for, which I don't know in this particular situation, but there's definitely an argument that could potentially be made. Don't know what the outcome would be in that, but if you, I don't know, it's.
Well, I think this one is a good question. Yeah, I think it's going back to the notice of non-payment. I'm guessing. The viewer can tell me if I'm incorrect, but I think they're talking about, hey, you've given me this notice of non-payment and I need to, get current in 5 days, but I don't know when you gave me this, so I don't know when the 5 days is up. I think the way to proceed, you're in housing court a lot more than I am. I could be wrong about this, but I think the way to proceed is to call your landlord and say, hey, I got this notice from you. It's got no date. I want to get my rent current. When did you start the 5 days? I'd like to come get my rent current and pay what I owe. So this is a general question that suggests that maybe an actual eviction hasn't been filed yet.
Oh, okay.
If the eviction has already been filed, it seems to me that you need to, like as you were just saying, let the court know that it wasn't done properly. I didn't get a proper notice.
Yeah, and then let the court
when the 5 days started.
Yeah. Yeah, these are some great questions. I'm interested to know what the other ones are. But does anyone else have any other questions about the notices from the landlord? Because the next slide is going to be going into notices from the court.
Yeah, I think a lot of these still are general. There is one asking about a 14-day notice. And I
Okay.
guess we'll just have to answer that maybe with at the end. But it says, I was given a 14-day cure that did not specifically say the lease would be terminated, but would put the tenancy in jeopardy. Now, of course, that's a specific
Yeah, that's
case that we can't really address.
No.
But again, I think anyone who's viewing now can go back and watch the replay of this on our YouTube channel, and Holly definitely did, I think, address that at the very beginning, really, where she talked about what exactly is required in the notice.
Yeah,
If all of that is
definitely
in
look
your
at that.
notice, you got to bring it up if they try to take you to court. All right, well, let's let you go on and talk more about the landlord, and then we'll look at some more questions.
Okay. So now we're moving on to notices from the court. So you've been given a notice, or hopefully you've been given a notice, and so we've passed the point where the landlord was supposed to have given you a notice. Now the landlord's filed an action with the court. So the first notice from the court is called a rule to vacate. Like I said, I did include pictures from the SC Court website for you to view. It's typically with an application for ejectment. The application for ejectment is what the landlord fills out. It's, basically, this is why I'm filing this action. The rule to vacate is what you should be getting in the mail. And a lot of times, what really throws people off with this notice is that it says failure to vacate the premises or respond within 10 days may result in the issuance of a writ of ejectment. And a lot of people get stuck on the first option, which is the vacate. But that's just one of the options. You can either vacate or request a hearing. And also it's important to note that you need to, if you're going to request a hearing, you need to request a hearing with 10 days after you are served, within that 10-day period after you are served. So that's important to keep in mind, that you do have an option. If you want to leave, you can do that. If you want to request a hearing and defend yourself against the eviction, explain why you should not be evicted in court and just have your day in court, you should request a hearing within that 10-day period. Are there any questions about rule to vacate before I move on?
I don't see any, but I'm still looking here because we do have a lot of questions, and I want you to have plenty of time to complete your presentation. So why don't we wait till the end, and whatever we don't have time to answer live, we can certainly answer when we post the presentation to YouTube. We'll answer any questions that we're able to. But if there's time at the end, we'll address all the questions that are left.
Okay, sounds good. So now I'm moving on to writ of ejectment. I've also included that on the slide from the SC Court's website. This is after, if the judge rules in favor of the landlord, they issue writ of ejectment. You have as little as a tenant would have as little as 24 hours to vacate after being served with the writ of ejectment. And they can either vacate or appeal the eviction decision. So there, of course, once again, are two options: vacate if that's what you would like to do, or if you want to appeal, challenge the judge's decision, and if you believe the court did something wrong, of course, you have that right to appeal the eviction decision in that case. So that is the writ of ejectment. And any other questions?
Okay, well, maybe we do have a couple of minutes. We don't want to go over an hour, but let me give you a couple other questions that we have here. Okay. Does the statute say what manner of delivery of the notices? In other words, does it matter if it is sent by regular mail, certified return receipt, or if it's hand delivered?
So the
Of course, that's up to
statute,
the landlord, I guess, how much they want to be able to prove that the tenant got the notice, right?
yeah, I mean, it really, as far as how it's delivered, I mean, it needs to be, obviously, I mean, if the landlord sent it to like the wrong address or put it like under the mat or in a way that there was no way for you to get it, I mean, I guess that would be an argument. But as far as the specifics, I mean, check the lease agreement too, because sometimes the lease may address how notices are normally given and how they expect notices to be given to them. And it may just go back and forth about that. So I guess, I mean, it really just depends.
Yeah, I mean, that's a good point, but it does depend on what your lease says, because a lease might say that it has to be by certified mail. That
Yeah.
just goes back to the point, that was made earlier, that every case can be different. And it's all about what can be proven in court. And so I think that as tenants, you have to be careful that you don't ignore any notices that you actually see. And as a landlord, if you're a landlord, you want to be sure that you can prove in court that you did give whatever notice is required. And, I would think that the best practice for a landlord would be to do that either by hand delivery, where the landlord can testify under oath that they delivered it to the tenant, or certified mail. I don't think it has to be return receipt, but I think that would be preferred. But as long as you can certify that it went to the address of your tenant and was actually delivered, then it is up to the tenant to check their mail. And ignoring your mail is not, I don't think. You tell me, Holly, because again, you're the one that's in housing court more than me, but I would think that that's not a good excuse.
Yeah, definitely check your mail, but also, once again, everyone needs to read their leases thoroughly and make sure that they understand the terms of their lease, all the terms of their lease, especially pertaining to what it is they're unsure of, because that could potentially answer their questions. Because everyone's situation is different. All lease agreements are different.
Yeah, and I'm sure that, that's something that we do as lawyers when there's a document that governs the situation, like a lease does when it comes to eviction. The first thing that you, I'm sure, as a housing lawyer do is to review the lease.
Yes.
And see what the lease says. Then you can start to look at the facts of a particular case and decide what defense there might be. And so, see if I can see anything else. Oh, there's so many. But I'm trying to get to them all that you haven't already answered. Okay. I think you could answer this one pretty easily. Can the landlord use the lease as notice of the violation?
No. So that's a really good question. No, they cannot use the lease agreement as a notice of, and I'm assuming they're talking about the 14-day notice. Yeah, no, that's for the statute lays out that it is an option when it comes to a notice of non-payment, when it comes to the notice to cure and all of that. You cannot put that in there, because how are they going to know how you're going to breach the lease? And they have to specify what the breach is, or what it is you did, what you didn't do to breach the lease agreement, and they can't possibly know that before you do it. And they have, so that's not proper. Just put it in.
And I think that answers the next question that I was going to read out to you, and that is how specific does the notice have to be? Does it have to clearly spell out that the lease is violated? And I think that you just answered that. It does have to clearly spell it out, and it has to say exactly how it was violated. And for a landlord, the best practice is to say what section of the lease they're talking about was violated, and then tell you, how you violated that.
Yes, it's important for, and when it comes to like if an action is brought for alleged lease violation, it's important for the person to know what the tenant to know what the alleged breach is, so they can respond, they can defend themselves. If they didn't do it, that's their defense. If it's not actually a violation of the lease agreement, then they'll know what they're being accused of, so they can make that argument. But otherwise, if it's, oh, you breached the lease, well, how?
Right. And the next question is, are there any things that will not require that notice, like illegal activity or something of that nature?
Yeah, illegal activity, absolutely. That's a big one, and I could
But
kick myself for not doing that.
But they still
So
get the notice.
Oh, I'm sorry.
I think the question was, do they still have to give you notice, even if it's something illegal, like illegal activity?
Well, notice, I mean, not the 14-day notice to cure, but definitely like, that notifying you that you've breached the lease. It could be like a notice of termination under that, but that's actually, but not a 14-day notice to cure though. That's not required when it comes to illegal activity.
Okay. Let's see. Can your landlord send you a request for rent on the day it is due, like using Zelle or Venmo? Can they send you, I guess you can send a pay request in other situations, but is that something that a landlord can use to request rent from you on the day that it's due?
I'm not aware.
But whether or not you have to do it is another question.
Yeah, I'm not aware of any rule that says that's not okay. I know this just kind of goes back to the whole, everyone's lease agreement is different. The landlord-tenant relationship may be different. An individual as a landlord versus a property management company. I mean, everyone runs that, everyone's different on the way that they handle, rental payments and how they want the rent to be paid and how the mode for which they'll accept the rent. So as far as I know, that there's nothing wrong with that. If that's how they
look at the lease, right?
Right. Yeah. Once again, look at the lease.
Now there is a question regarding retaliatory eviction, or I guess wrongful eviction, and the treble damages idea. Is it 3 times actual damages or 3 times the rent, or is it the greater of the two? And I think the statute addresses that.
Yeah, it does. And I can't remember off the top of my head. But
we can provide that in the comments.
Yeah, but it's definitely laid out in the statute with the damages you would seek in that situation.
All right. And then one person asked if you could put back up the application slide from the 5-day notice to pay in a separate writing.
Okay, I can do that.
Let's just say, because we are at the end of our time,
okay.
but we will post the slides.
Okay.
With the YouTube video on our YouTube channel, so you can find it there. And I'm so sorry we don't have any more time for questions. I appreciate everybody's great questions. And Holly, if you'll go to our last slide, I do want to thank everyone for joining us today. And we will provide as much information as we can for everyone after or when we post the video to YouTube. We'll give all the information that we possibly can to address the questions that everyone has answered, and we will post a copy of Holly's presentation there with the video as well. And you'll see here on your screen all of the information about applying for our legal assistance, which is free if you're eligible. And so for those of you who have some specific questions and you feel like you need to get some advice from a lawyer about how to handle it, I encourage you to call our intake line number. We've got intake specialists standing by Monday through Thursday from 9 to 6. But you can apply online 24/7. So try that if you're not able to get through on the telephone line. We really encourage everyone to do that. Again, we have our QR code here that you can scan to get a copy of our newsletter. But otherwise, you can see here all of our website information, our social media information, and you can get so much information there. You know, I think one of the questions asked about, you know, wrongful activity or improper maintenance by a landlord. We have a Level Up Law episode on that. We actually have an online classroom on that you can find. So tells you exactly what you can do as a tenant. But otherwise, unfortunately, I have to say that concludes the presentation today. But Holly, I want to thank you so much for a great presentation. I know you are in and out of the housing court all the time, and it is hard to answer questions when there's so many specific situations that happen. So we do appreciate your willingness to try to answer some of the questions. Now, to our audience, if you did find this helpful and you know it's going to be helpful to others, or you want to see it again and check out the additional information that we're going to post, please do go to our YouTube channel, and we appreciate you sharing out the video. Give it a thumbs up too while you're there. We do want as many people as possible to get this important information. Holly, I want to thank you for your presentation on a really unique and interesting topic that is very timely right now, because we do have an awful lot of eviction that is happening. But I also want to thank the audience for tuning in. We really appreciate when you tune in live. And on days like today, we wish that the show could go on until we've answered every single question. So we do appreciate that, and we'll try to get to those when we post to YouTube. But I do want to invite our audience to also be sure to tune in next week for another episode of Level Up Law on Tuesday at noon. We're going to have a special presentation about the featured presenters from our partner organizations that we had in this year 2022. We've had some great partners who have been willing to step up and give information about their organization or programs that they have. And we really want to thank them for doing that and encourage more of that in 2023. So thanks, everyone. Thanks to Holly. We look forward to seeing you next week. Thanks again for tuning in today on Level Up Law. That concludes today's webinar. Take care, everybody.